Hi, my name is Dan Fowler. I'm president of the Apartment Owners Association of California. We're one of the largest individually organized group of apartment owners in the state. And so I want to welcome you today to this live stream seminar, and I'm sure you're going to get a lot of good ideas and learn a lot of things that even most attorneys out there don't know yet because this bill that we're going to cover is so complicated. 2020, I call it the year of free rent. And that's just about what's happening to everybody during this year. Whoever thought you'd be required by law to provide housing for free to some of your tenants? Had you ever think of that 5 years ago? That thought you say, oh, Dan, the politicians wouldn't do that. That's morally wrong. I should be paid for services that I provide for other people. Well, that's a problem with our politicians today. They are morally wrong. They have lost their moral compass. It's gone. They don't know the difference between right or wrong. They don't know what's right and what's wrong anymore. They don't know that it's wrong to force you to give of your services and your hard work to other people and let them walk away. Wouldn't it be nice? Wouldn't it be nice to walk into the grocery store, fill up your bags with $100 worth of groceries, come up to the checkout counter, give them $25 and say, so long, see you later, sucker? Wouldn't that be nice? No, it wouldn't be nice because it's morally wrong. Just as it's morally wrong for the politicians to force you to do the same thing. In addition to that, the grocery stores would close up pretty fast. There wouldn't be any groceries on the shelf. And you know what? Someday, the politicians are going to wake up and see that because of their rent control and all the laws that they've passed to take away our assets, and all the things that they've done are going to cause a lack of housing. And people are going to be on the street because there won't be housing there, even if they force you to give it all away because of these laws that they've passed. Someday they'll come to that realization. I don't know when that day will be. The Tenant Relief Act of 2020 is what it's all about, and that we're going to be covering in detail today. Now, AOA, that some of you say, well, what do I do? Where are my forms? AOA has the forms on our website. You can download them for free. Okay? The AOA website, aoausa.com. You can go there to get the forms. Now, we're going to cover the use of these forms and the laws that this new thing that the politicians are forcing upon us by one of California's foremost landlord-tenant attorneys. And he spent a lot of time on this law already, looking for the interpretations of it and all the different ways that it can be interpreted. Let me ask you first, before we get into that and before we introduce you to this attorney, let me ask you to take 4 easy steps to protect your property today. Proposition 21 is coming up. It's going to take a lot of money, of course, to win that again, just like it took millions of dollars 2 years ago to win Prop 10. Now, we also have Prop 15 and Prop 19 that I want to encourage you to vote no on. But Prop 21 is where our focus is going to be here at AOA. Number 1, I want you to sign the Aoa Petition. Please sign that petition. Go to aoausa.com. You'll see the petition there. Go down just a little bit, and over to your left, you'll see the petitions. Click on that. Go to the petitions and sign. Say, Dan, I've already signed it. Go to it again. Download that letter that's in there and send it to Gavin Newsom, okay? Send it to the governor. We sent some 88,000 signatures of those petitions when they're in the middle of negotiating this new 2020 Tenant Relief Act, and it is relief for the tenants. There's no relief for you. You're not going to find much. If our speaker can find anything good, he's going to tell you about it, but I don't think there's much there. So you need to send this. We need to do this together, a group. Say, well, my one letter won't do any good. No, your one letter probably won't do any good. But if 20,000 of us who are members of AOA send that letter in, you better believe they're going to pay attention to it and their heads are going to go up. Download it, send it to the governor. Step number 2, the bumper stickers that we put out. Here's the bumper sticker that was in the AOA magazine this month. You say, Dan, it wasn't in my magazine. Go through page by page in your magazine and it'll pop up. If it doesn't, call in to AOA, give us a call, 800-827 800-827-4262. It's on the screen. 800-827-4262. Leave your mailing address, or you can email it in. Leave your mailing address and whether you want 1 or 2 bumper stickers. If you have a second car or a third car, you may want more than just 1 bumper sticker, and make out your request. There's no charge for those, so you can get them for free. Let's get them on every car out there on the freeway. Step number 3, post your yard signs. Now, the yard signs will be coming in 2 or 3 weeks. We'll be mailing them out. Yes, mailing those big things out to you. If you've made a donation, to the AOA Political Action Committee within the last couple of years, you'll get a sign in the mail. Now, if you don't get that by the end of the month, if that sign doesn't come, give us a call and we can send a sign out. If you only gave your post office box number, you will not be receiving a sign. If you donated and you didn't leave a mailing address other than a box number, you're going to need to call in to get your copy of a sign. Step number 4. All these things are going to cost money. You have lawsuits, pay for the yard signs, the bumper stickers, the mailings, TV and other promotions when we join together with other groups that have to be paid for. Send money in. Every member of AOA should donate at least $1,000. $1,000! Dan, I can't afford $1,000. I was talking to a man on the phone the other day, and I said, nobody's donated. Well, I can't afford to donate. And I said, you know what? I hear that from every member of AOA. You'll hear that even from members who have a couple thousand units out there. And so don't kid yourself. Face the facts. You can afford to protect your property and spend $1,000. You pay more than that for insurance each year. And this is somewhat of an insurance policy to stop these guys from taking away more of your property. So send your check to the AOA Political Action Committee. It's up there on the screen. Check payable to the AOA Political Action Committee, or AOA PAC, at 6445 Sepulveda Boulevard in Van Nuys. Send your check there, or you can go to aoausa.com /PAC. aoausa.com /PAC, and you can make your donations there on the website. Again, I want to welcome all of you to the live streamed webinar today. We're glad you've tuned in. Stay tuned in. As I mentioned to you, we have one of the foremost attorneys, landlord-tenant attorneys in California, is going to bring you an explanation of this Tenant Relief Act of 2020. Before we do that, I'm going to ask Jeff Fowler. To come up and introduce our next speaker. Thank you very much for tuning in today.
Great, thank you. All right, thank you for joining us today. And we just would ask you to like us on YouTube and Facebook. And if you have if you'd like to share as well with your friends this live stream, let them know about it. And after the fact, it's still going to be there. So go ahead and share it with your friends so that because all these things are just changing, and it's really important that everybody knows, and there's penalties and fines when you don't do the right thing. And so yeah, that'll help. And then comment. You can comment down below. For the website, the AOA website, there's a help button. And for Facebook and YouTube, you can just comment there, and we'll take those questions for you. And then also, if you are interested in this kind of content, be sure to subscribe to the YouTube, and then that way, when you hit the subscribe button, there'll be a little bell that pops up, and with that, you can toggle that so that you get automatic notifications when we have new content. So go ahead and hit that subscribe. That way, you won't miss anything. And then another way that you can keep from missing anything is subscribing to the newsletter that we have, and you can do that by going on the AOA website, and you can click on a button there, and you put your name and email address in, and you'll get the emails that we send out telling you about these events. And speaking of events, our next event is coming up on September 17th. And we're going to have Bay Area attorney Richard Beckman speaking. And so that'll be a great time to hear more about this change in environment, and just as we go, I think even by that time things will have changed yet again, and especially for our Northern California members, that'll be especially good for you because he'll know more about your local laws, and he'll be able to help you more specifically. So again, our goal here, just to want to share with you about AOA and the association here, and what we can provide for you. And first of all, if you are a first-time member, if you've never ever been a member before, we would love it for you. We'd love to give you 6 months free, a free membership. And so that can happen if you email to membership@aoausa.com, write your name and let me see, what else do they need? And your phone number, and they will get back to you, and we'll get you signed up. Or you can just, do that. And also, just so you know, membership is only $79 a year. There's no per unit charge, and so we're definitely one of the best values out there. And some of the member benefits that I'll go over today, we have the advising, and so things are changing, and so you can call in and get help from our staff here, and they're answering questions all day long, and they can help you get the right answers. And then we have local offices, and they have local knowledge. They know specifically in your area what the rules are, and they'll be able to help you with that as well. And then also, just an announcement, because of AB 3088, there are some new forms that are required, and so AOA has 3 new forms that are available for you. Dan mentioned it before, but those are available for you. So don't leave without taking a look at those forms. Also want to mention AOA Tenant Screening. And just the cost of an eviction is at least $1,000. And if you pick the wrong tenant, you know that it costs more than that, just in the loss of having a good one. And so you really want to screen your tenants. You really want to do that properly. And AOA Tenant Screening can help you do that. We have the magazine, and that's also for members, and you get that every month. It also does come out on the web, on our website, and it comes out at the beginning of every month, so that's there for you to take a look at. And debt reporting, like we announced last time, you can report your debtors. If they have vacated, you are able to report them. And under certain circumstances, we can't report to the credit bureaus, but in most cases we are able to report them to the credit bureau so that it goes on their record. And just remember the golden rule: we all do unto others as you'd have them do unto you. And so if you think about how you would like to know if this applicant has been paying their rent and is in good standing with their current landlord, and in the way that you would like to know that, remember that there's another guy, there's another landlord just like yourself that's also would like to know what's going on. So for all of us, if we're in it together, let's report those debtors. And we have the brokerage, and if you're interested in selling your property, you can get a free property valuation from them, and that's as for members only. And then also, there are many of you that are ready to buy more, and we support you completely wherever you're at, and we're hoping and praying that this year we're going to get through this thing. It's very difficult. And I also want to mention Livable. It's a smart utility billing service, and they can help you peg a varying expense and make it and peg it to something that's fixed. And so they're able to help you even if you have just a few units. They're able to do that, and so we selected them specifically because of that. Insurance, we also have specialized insurance for apartment insurance and tenant insurance and lots of other offerings. So you can call the office and learn more about that. We have pay rent, and you can have your tenants pay rent through the pay rent portal. And again, Dan mentioned the Political Action Committee. It's really about grassroots, and we want to mobilize, we want to empower you guys so that your voice is heard all around. And just again, we will take questions at the end, so don't forget to write your questions down in the comment box. And now we finally get to the speaker. Our speaker today has been tremendously successful, very effective, and he's been in the business for 44 years. He's been partnering with us for years and years, or we've been walking shoulder and shoulder for years and years. And he's probably evicted more people than anyone in North America. I could almost guarantee it. He's done all types of evictions, commercial as well as residential, and he has a wealth of information, a wealth of experience, and he's been studying. We were thinking of doing this live stream yesterday, but he spent extra time and wanted to really make sure he knew and was able to grasp the material here, because it is very complex. And so he's ready to share with you. It's my honor to introduce to you Dennis Block. Thanks.
Thank you, Jeff.
Okay.
Well, good morning, everybody. I stand before you again with new facts, new laws, of course, all adverse to landlords. As Dan was talking regarding the imposition of free rent, that's exactly what we have. We have our government elected officials basically ordering landlords to give their services away for free. It makes no difference whether they have to pay their own mortgages, their own property taxes, do the maintenance for the building, keep up with the utilities for the building. It makes no difference. We're basically being forced to give free rent. They just passed, as of August 31st, Assembly Bill 3088. It has been codified. It is now the law of the land, and unfortunately, landlords are truly going to suffer under this new law. I'm going to tell you about it. I'm telling you that this law is open to different interpretations. There will be raging battles in court, which of course will only add to the cost of the landlords in terms of operating their own business, but it's been written in a very unusual way. And again, it will cause for much litigation on this subject as to what it actually means. I'm going to start to talk to you about this statute, the Tenant Relief Act. And you're right, it is the Tenant Relief Act. It has nothing to do with the Landlord Relief Act. But before I start, I want to tell you things that we can do right now. So let's get to the good stuff. There's not much, but at least let's talk about stuff that landlords can do right this moment. If you have a tenant who has violated a term of their rental agreement, not with the exception of rent, that lawsuit can proceed immediately. So for example, if you have a tenant who's done an alteration to the premises, if you've had tenants that bring in unauthorized tenants, nothing prevents a landlord from serving a 3-day notice to perform or quit and proceeding forward with that lawsuit right now. If you have those lawsuits, and we have them already in the pike, we can now proceed forward with those lawsuits. We can get a summons issued, and we can proceed forward. Also, if you're in a non-rent controlled jurisdiction, and you have a tenancy that terminated by its own terms. Let's pretend you had a lease that expired as of August 31st. Maybe it's a single family home. Nothing prevents the landlord who does not want to have that lease renewed from bringing forth an unlawful detainer action right this moment. Those cases are free to go forward. Again, this is a short list, ladies and gentlemen, but I'm going to go over the ones that we can do right now. If you have tenants that haven't paid rent prior to March 1st, 2020, those cases can be commenced right now, and they can proceed formally as of October 5th, 2020. That's when the statute authorizes us to be able to get a summons, which means that as of October 5th, the case can fully move forward. Those are for any cases where rent is owed prior to March 1st, 2020. That's an important date. Write that one down if you're making notes. If you have a tenant, for example, that didn't pay rent from December, January, February, and of course, all the way through to today's date, in those cases, we have been serving a 3-day notice to pay rent or quit, but only asking for rent from December through February. We're not going to cross that March 1st line. Those cases can proceed as of October 5th, 2020. The same is true, and we have tons of cases in our system already, where notices were served for rent prior to March 1st. The lawsuit was filed. The lawsuit was served, but based on the illegal actions of the Judicial Council, that was the one where I had filed the lawsuit against it, that law was revoked, but unfortunately replaced with our AB 3088. But as to those cases which included rent prior to March 1st, but the lawsuit's already filed, those cases can also proceed as of October 5th. So we're going over all the cases that we can go forward with right now without much of a delay, either immediately or in cases involving rent. That would be October 5th. Also, many of our members here and people watching also have commercial cases. AB 3088 does not involve commercial cases. AB 3088 does not involve commercial cases. If you have a commercial tenant that has not paid the rent, the state law does not prevent you from either serving a 30-day notice to vacate on a month-to-month tenant who's commercial, or serving a 3-day notice to perform or quit, a 3-day notice to pay the rent and proceeding forward with an eviction at this time. There is no delay to commercial cases. But I do have to tell you that while AB 3088, the Tenant Relief Act, does not involve commercial cases and really only deals with residential property, and part of the confusion with this law is that your local municipality laws do not go away. So whatever the local municipality had with regard to protection for commercial tenants, with regard to protection for residential tenants, those cases are still active. And you have to comply with not only the state law, but you're also going to have to comply with the local jurisdiction. For example, on a commercial case, if you have a tenant who has not paid rent, the Tenant Relief Act doesn't apply. So you could immediately serve a 3-day notice and proceed forward with an eviction and have the court issue a summons at this time. But unfortunately, if your municipality said that commercial businesses are protected, then in that situation, you would not be able to serve a 3-day notice to proceed. Some jurisdictions are saying that until the pandemic is declared over, that the tenant will then have 3 months to pay the rent. Some jurisdictions say 6 months. It depends what jurisdiction. So we're going to go with the date of October 1st. So any rent owed to a commercial establishment prior to October 1st, those rents would be deferred. So while the state is not imposing any restrictions with regard to commercial evictions and enforcing of contract rights, unfortunately, you're going to have to check to see if your local municipality has any rules. Okay, let's continue on with good things. And that is that as of February 1st, 2021, basically everything I'm telling you now is revoked. Because at that point in time, landlords will be able to serve a regular 3-day notice to pay the rent or quit for any rent owed from February 1st forward in time, treat it like a regular unlawful detainer. So if there's any hope on the horizon of when you're eventually going to be able to get rent, clearly that date will be February 1st of the year 2021. February 1st of the year 2021. Well, that concludes all the good parts of all the things we can do. Unfortunately, now we have to get into the AB 3088, the Tenant Relief Act, and basically what they should call it is the Free Rent Act of 2020, because that's really what it is. First thing landlords of residential property need to know is that if you had a tenant who did not pay the rent anywhere from March 1st to September 1st, you need to serve on that tenant a specific notice to the tenant pursuant to California Code of Civil Procedure 1179.04. You don't have to think that out too hard, because all you got to go to the AoAUSA.com website, and that form is there. That form must be given to any tenant who has not paid rent for that period. Once again, the period is March 1st through September 1st. If you endeavor to serve a notice to pay rent or quit and you haven't served that notice, your notice is defective. So again, even if the tenant has claimed that it's COVID related, sent you forms and anything else, it makes no difference. This form has to be given to any tenant, any residential tenant in the state of California who has withheld rent for any reason from March 1st through September 1st. So again, that form is on the AOA website. Okay, so the Tenant Relief Act is broken down to two periods. Just to complicate things, that's what they did. So we got to write these dates down, ladies and gentlemen, and that's called the protective time period versus the transition time period. I kid you not. So let's talk about the protected time period first. That's any rent owed from March 1st through September 30th. That's called the protective time period. The transition time period is any rent owed from October 1st through January 31st, 2021. Okay, so protected time, once again, March to September. Transition time period is from October 1st through January 31st. Now, if you have a tenant, and we're going to talk about the protected time period first. If you had a tenant that withheld rent from March 1st through August 31st, you have the right to serve on that tenant a notice to pay rent or quit. That is a 15-day notice to pay rent or quit. That form, again, is on the AOA website. Don't even think of creating that form yourself, because you will not do it correctly. Accompanying that form, it has to have a notice of tenant of certain requirements of this statute. So that's the second part of this 15-day notice. The third part of this notice to pay rent or quit is a blank declaration that your tenant will have to sign under the penalty of perjury that the reason why he didn't pay rent from March 1st through August 31st is because of the pandemic, that it was causally created as to his inability not to pay rent. Of course, we can go over those rules quickly, which is that he either lost his job or he had to stay home to treat a sick family member, or he had to stay home, or she had to stay home to take care of her kids who aren't allowed to go to school at this time. But anything that's affected, or loss of wages, doesn't have to be a complete loss of job, loss of wages. he would have to check under the penalty of perjury and get that form back to you within the 15-day period. If he does, or she does, that means that rent's deferred. Deferred. Doesn't have to pay you. If the tenant you know is earning at least over $100,000, you can, and you'd have to know this maybe because of the application, you can ask for additional proof, not just a signature on a declaration, as to him to show or her to show income tax statements or requirements from an employer or monies in a bank account. You can ask for that only if you know that that tenant is a high wage earner or high income earner with over $100,000. If you can establish that, then you can ask for additional proof in addition to this pretty meager declaration that you're going to be included with your 15-day notice. Now, let's pretend that the tenant doesn't give you back that 15-day notice, that declaration within the 15 days, or doesn't pay. Of course, the tenant could pay. That's fine. But if he doesn't pay and he doesn't give you back the declaration, you have the right at that point to go forward with an unlawful detainer action. It will fully be able to go forward as of October 5th, 2020. Let's move on. If you're in a situation where you're asking for rent from October 1st through January 31st, so of course that you wouldn't be asking now since it's not due, but when the time comes, if you don't get your rent for October 1st, then actually it's from September 1st, excuse me. From September 1st to January, you would again serve a 15-day notice with that information form and a declaration that the tenant can fill out. But for rents owed from September 1st through January 31st, that tenant has to pay at least 25% of the rent. Okay? Let me correct something that I said. The transition period is actually starting as of September 1st through January 31st, and the protected time period is from March 1st through August 31st. Okay? So I misspoke. Let me get that straight one more time. The protected period is from March 1st to August 31st. The transition period is from September 1 through January 31st. So if you had a tenant, let's go back, if you had a tenant who didn't pay rent from March 1st to August 31st, you would serve that 15-day notice with the information sheet and the declaration. If he does either pay you the rent or gives you the declaration back, then that rent is deferred, period. If after, as of September 1st, if you don't have your rent from this tenant through January 31st, you are allowed to serve that same 15-day notice, the information sheet, and the declaration. However, the difference is if it's a transition period, once again from September 1st to January 31st, then the tenant has to pay 25% of the rent. They have to give you back that declaration within 15 days, but they'll have until January 31st to pay you the 25% of the rent. So even though you didn't get your 25% within that 15-day period, you still can't go forward with that until after January 31st, because it's extended until that date to pay you that rent. Okay? So, once again, if you're in the protected time period, that's from March 1st to August 31st, if you get that declaration back within the 15 days, then you cannot proceed forward with that lawsuit. That is considered deferred rent, and I'm going to go into that in a second. With regard to the time period of September 1 through January 31st, the transition period, he has 15 days to get you back that declaration. He is obligated to pay 25% of the rent, but he'll have until January 31st to pay it. So in that transition period, if you served it and he gave you the declaration, if you don't have your rent by January 31st, that 25% only, then you could bring forth an eviction based on the failure to pay that as of February 1st. So as of February 1st, you're free to go forward with that initial 15-day notice that you served. But what about rent owed during the protected time period? Remember, I said if you gave a declaration, then that rent's deferred. But really, is it deferred? Because you see, the legislature has now defined that rent, be it the rent between those first two dates versus the transition period, as not being rent anymore. It's considered a civil debt. They were very clever in why they called that amount owed a civil debt. Because you see, a civil debt is not rent. And if it's not rent, then you can't bring forth an unlawful detainer action. So for rents owed between March 1st, 2020 through August 31st, 2020, even if you get to February 1st, you got the declaration, now that rent is now supposed to be due, that is not considered rent. It's considered a civil debt. And as a civil debt, all you can do is file a civil lawsuit. So there's really not much teeth in that, because it's not like the tenant is going to be facing an eviction for this rent for that period of time. The same thing is true for the transition period. While 25% is due, 75% is not due. And again, that 75% again is going to be considered civil debt, which means that you cannot proceed forward with an eviction action after February 1st, even though the tenant hasn't paid you. He owes it to you, but he owes it to you in the form of a civil debt, which means you could file a small claims court action, and the legislature graciously allowed you to go above the $10,000 figure, which is the normal limit for small claims court, or you can hire a regular civil attorney to file a lawsuit in your behalf, either one. But again, it's not like there's going to be the onerous to the tenant that, gee, if I don't settle this case, I'm going to get evicted. So basically what we're talking about, unless landlords are really going to stand on their rights and bring forth a civil lawsuit, which can be timely or costly, etc., unless they go through small claims court, but that's, of course, is going to be timely, then that's basically going to be free rent. Either the 75% is going to drop off and be free, or all rent owed from March 1st through August 31st, that rent's going to be considered free. And that's why the legislature declared this to be a civil debt as opposed to rent. Okay, so hopefully everybody's clear on that. When you're serving this 15-day notice to pay rent or quit, obviously it has to be served like any 3-day notice used to be served, and that is, it either has to be handed to the tenant. If the tenant is not there, then you're allowed to post one on the door and mail one. When counting, they give you all this extra time, 15 days, but when counting the 15-day period, you have to exclude Saturdays, Sundays, and judicial holidays. So a 15-day notice probably is going to be, with a holiday in there, probably is going to be about 22, 23 days later. So every consideration that you can possibly imagine is afforded that tenant in this situation. Now, they also have issues dealing with cases that aren't dealing with non-payment of rent in this statute. So if you have a single-family home which is not subject to any rent control, right now through the date is February 1st, you cannot terminate that tenancy unless you have good cause. I don't care where the jurisdiction is, single-family home, condominium, it really makes no difference. You cannot terminate that tenancy. You can't serve a 30-day notice or a 60-day notice, depending if the tenant has been there longer than 1 year. There are some exceptions. The exceptions would be that if you want to have your own family member move in, that would be an exception. The exception would be that if you're going to either demolish the place or renovate the place because you're under a government order to do so, then that would be also grounds that you could terminate a month-to-month tenancy where no rent control exists. So in that situation, you can go forward, but only in limited circumstances. So basically what you're going to have to do is you're going to have to wait until February 1st before you try to terminate any tenancies. You also have a situation which I'm sure the real estate brokers added to the statute, where if your house is in escrow and the buyer intends to move in that situation, you can also serve a notice to quit on a month-to-month tenant where no jurisdiction of rent control exists. That you can also do. But other than that, that tenant is basically going to be able to remain in possession of the premises at least until the 1st of February. With regard to the small claims court action, where the tenant hasn't paid you, the first opportunity that you can bring forth any civil suit or small claims court action for this, we call it a transmuted debt. They transmuted it from rent to a civil debt. That can't be brought until March 1st. So on March 1st, for any rent that is now wiped off the books, the landlord does have until March 1st, 2021. At that point, you can now bring a civil lawsuit for the money. So to recap, this Tenant Relief Act is truly no fan to landlords. It really is going to result in millions and millions of dollars of free rents. Only those landlords who are willing to proceed forward with civil lawsuits are they ever going to see any potential compensation. And again, even if you bring a civil lawsuit, who says you're going to get paid on it? A lot of times the tenants are going to move away. You're not going to know where they are. And of course, if you can't evict them, there's really no true incentive for the tenant to pay any of this money. So the tenants do have to sign under the penalty of perjury that, in fact, they had an inability to pay because of the pandemic. But the truth of the matter is there will not be one criminal action filed against any tenant from now to the end of time based on perjury of that declaration. That's just not going to happen. So to recap very quickly, if you have any rent that's owed prior to March 1st, file that lawsuit now. Let us go forward with it. It's just a straight 3-day notice. Don't ask for rent that became due as of March 1st forward in time. If you've got any other violation of the rental agreement, let's pretend the tenant hasn't paid rent, but also brought in an animal that is not prohibited. That case can proceed forward based on having pets on the premises in violation of the rental agreement. Commercial cases, unless you have a local jurisdiction which prevents you from moving forward, you can proceed forward with evictions on commercial cases. Again, do not lose sight of the fact that if you have a local jurisdiction which is prohibiting you from going forward with a non-payment of rent case, then you have to comply with your local jurisdiction. And every city has their own statute. So any questions, feel free to call my office. My office number, if anybody needs it, is 1-800-77-EVICT. I also have a website, which is evict123.com. I'm sure there's going to be a ton of questions, so let's open it now, Jeff, to our first question, and let's see if I can fathom an answer based on this statute, which again is open to many different interpretations.
Okay, we have a very responsible person. They're driving right now, so they actually emailed this question in yesterday. And it is, let's see, it's from Dennis. And let's see where they're coming from Norwalk. And this again, it came in through the email. And here it is. It says, "Thank you so much for all your great work for the benefit of all apartment owners. I'll be listening to the webinar today in my car, but will be unable to type a question." And so here's the question. "I filed a complaint on a commercial tenant about a month ago in Norwalk Court. Now that September 1st has passed, the clerk is refusing to issue a summons based on a general order from the presiding judge. The clerk cited Governor Newsom's recent bill. That bill appears to only apply to residential tenants. Is this a political ploy by the California Judicial Council to pretend that they have discontinued their involvement, but really not true? What will that be a problem for residential tenants too?"
Okay, so let's answer that question. With regard to AB 3088, that does not involve commercial cases. So the court clerk just hadn't gotten the updated general order so that they're issuing summons. So we're having summons issued, and the first ones that we put through on September 1st got rejected because, quote, they hadn't gotten the updated order. So if the gentleman, his name is Dennis, so if Dennis resubmits his summons, he should be able to get it on that commercial case. For residential cases, for Norwalk doesn't have its own eviction moratorium, but unfortunately the county of Los Angeles picks that up. So the county of Los Angeles states that there is an eviction moratorium if the tenant has an inability to pay rent due to the virus. So while the state, and we were even having an argument in my own office on this, while the state is saying, yes, for September rent, I can serve that 15-day notice. I can demand that the tenant sign a declaration. I'm going to give them that information sheet that I got from the Apartment Owners Association. But if, in fact, this party is under the auspices of LA County, and this is just for an example, LA County says that rent's deferred, at least through September 30th. So if it's deferred through September 30th, you can't serve a 15-day notice. You can't serve that declaration. You can be the subject of a lawsuit for doing that. And that's what I'm telling you, that there are different interpretations of this, because you still have to comply with the local jurisdiction. If you don't have prohibitions for a local jurisdiction, then everything I said today is accurate. So again, it's really up to the landlord to know what the local jurisdiction is and also what the state jurisdiction is.
Great, thank you. And here's a question. This is from one of our advisors, Allison, and here's the question. The owner has 3 mortgages and only enough money to live on until the end of the year. With the new SB 3088, what can the owner do about paying the mortgages when the tenant isn't even paying 25% of the rent?
I believe that the statute does have some deferment of rent from some financial institutions. But the bottom line is that that mortgage payment is going to have to be paid, and certainly going to have to be paid prior to the time limits as stated by tenants to pay the rent. So if we're doing the math here, remember this period goes from March 1st, 2020 to January 31st. You're talking, 10, 11 months right there that landlords are going to be without payment of rent, trying to not only take care of the maintenance and the utilities, but their own mortgage payment. And by the way, there's no relief for property taxes. So I don't really have an answer for that member who wrote that question, because unless you have some life savings, literally and I said this at the last seminar, literally where the media is complaining that there's going to be a tidal wave of evictions, the truth of the matter is there's going to be a tidal wave of foreclosure for landlords.
Yeah. Right. So it's very difficult, and we feel with all of you, this is a crazy time. Here's a really good question, and it is, which order does the owner follow? State the SB 3088 for no evictions until the end of October, or the CDC renter protection order of no evictions until December 31st?
Okay, again, the state law doesn't trump any local jurisdiction. So in that situation, you have to comply. So for example, as I said, that LA County states that you can't demand rent if it's COVID related through at least September, then you can't rely upon the state law. And that's really the difficulty in this. They should have had a uniform law for the entire state. At least let us know. But to sit there and create this law that kind of runs afoul of the individual local municipalities creates the problem.
Okay, and here's a question from Melody. What if your tenant has both quit paying rent and is also a nuisance? There's been tenant complaints and police have been called on them already.
Again, we cannot go forward with the rent case if the tenant signs that declaration that it's COVID related. But nothing prevents us from bringing forth other types of cases, as I described when I first started, which is nuisance cases, of course, and other violations of the rental agreement which don't include rent. So that's a case that can be started right now. We had to, prior to this new law and prior to the Judicial Council's illegal emergency rules, we had to, on a nuisance case, after we served it, in order to get a summons issued, we had to go into court on a special ex parte motion, an emergency motion, have a hearing in front of a judge, and then finally get authorization to have the court clerk issue a summons. Now, for any of these other cases, we can proceed forward. If you've got tenants who aren't paying you rent, you know you can't proceed on that basis because it's so simple for a tenant to give any kind of a declaration that states that it's COVID related. But you certainly can proceed based on nuisance or other violations of your rental agreement. And by the way, when I talk about rent, the statute, AB 3088, the Tenant Relief Act, talks about any rent, any monetary obligation. So if you had a tenant that owed a security deposit, that's also considered a monetary obligation. If that security deposit was owed and the tenant didn't pay it from March 1st forward in time, it's treated as if it's rent. But if you had a tenant, for example, who didn't pay the security deposit and it was prior to March 1st that it was due, that would be a wonderful case for eviction, a 3-day notice to perform or quit, and we could proceed forward with the eviction.
Okay, here's another good question from Melody. What happens when there are roommates and one moves out and the other stays? What happens with the unpaid rent?
Well, I get this question a lot. When we talk about roommates, somehow people think it's different when you're talking about a husband and wife. And what if the husband moved out? There's less confusion in that situation. But the truth of the matter is, your tenants are a partnership, be it a husband and wife, or be it just regular tenants cohabitating together. That's a partnership. If one tenant vacates, okay, both tenants are still responsible for the rent. The only time that responsibility would end would when the partnership terminates the tenancy. In other words, the place is vacant. So in that situation, if the landlord could serve that same 15-day notice, and if I don't get a declaration back, I can commence the lawsuit. Oh, which reminds me of another thing. a crazy thing they put in the law, which is you've complied with this law. The tenant didn't pay you the rent come March 1st. You served that 15-day notice. The tenant didn't comply by sending you a declaration, and you paid to have an unlawful detainer filed. And then you served that unlawful detainer, and God knows, based on even this law, you're allowed to go forward with it. Or can you? Because you see, they're giving the tenant a double bite of the apple. All the tenant has to do is file with the court that same declaration that he didn't serve you within the 15 days. And if he serves that declaration on the court has to have a hearing within 5 to 10 days. And if the court finds that it was excusable neglect, it was a mistake on the part of the tenant, then that case is ordered dismissed. Can you imagine? So you served the 15-day notice, the tenant didn't pay you, the tenant didn't do the declaration. What are you going to do now? Well, of course, you're going to file an unlawful detainer. So you file the unlawful detainer, you serve the tenant, and then within the time period for the tenant to answer that lawsuit, if he files that declaration, it's a get-out-of-jail card. You've just wasted all that money. And all the court has to do is find that it was excusable neglect. Well, I can tell you from the state of affairs by most judges, they're going to find it was excusable neglect, or he didn't understand, there was a mistake. So even cases where you're complying with the law, this wonderful legislators and our wonderful governor gave them another bite of the apple to do what? That is to waste your money filing lawsuits.
Wow. And like the courts aren't going to be busy enough.
You got it.
Okay, this email is from Diana. Does just cause now apply to tenants who have been renting less than a year?
Yes, it does. Under this statute, through February 1st, you need to have good cause to evict, except for those exceptions, which I mentioned, which is that if you are selling the property and the buyer is going to be moving in, or you want the property for a family member or a close family member, or you have to do major renovation because you've been ordered to by a governmental order.
Okay. Let me see. Here we go. Now we have an email from Carol. And what is the date when we can attempt to collect whether or not they pay 25% rent? Per HCID LA, they do not owe rent for 12 months after the pandemic is over. The state law appears to state that differently.
Absolutely correct, and that's a great question. So the city of Los Angeles says that your rent is deferred for 1 year. 1 year from when the pandemic is declared over. God only knows when that 1 year will start. My guess is that it's going to be as of February 1st. So as of February 1st, 2021, they won't owe this rent until February 1st, 2022. But we already heard that, I can file a small claims court as of March 1st based on the state law. But you see, the state law doesn't control. And that's the confusion. It's the local municipality that controls. So if they say the rent is deferred for 1 year from when the pandemic is declared over, then that means you can't, number one, you can't go for non-payment of rent in terms of an eviction at that time. It's still considered to be a civil debt. And all you can do is bring forth a small claims court action, but when? Not on March 1st, 2021, more like March 1st, 2022. And you tell me how many landlords are going to be going after their money after that amount of time? How many landlords? Ladies and gentlemen, they might have called this the Free Rent Act of 2020. That's exactly what it is. It's not tenant relief. It's the Free Rent Act of 2020.
Okay. A year of free rent. Here we go. So Carol has another one with AB 3088. When are they supposed to begin paying at least 25% of the rent due?
Well, again, if you're talking about the city of Los Angeles, then that's not going to be for a year for this period of time until they declare the pandemic over. Whether that's going to be October 1st, I'm not sure on that. It's really kind of up in the air. Is it going to be February 1st? I'm not sure. But if, in fact, you are dealing with a non-rent control where there is no eviction moratorium, then in that situation, this statute says that the tenant has 15 days to give you that declaration. This is for rent owed from September 1 through January 31st. For that period of time, the tenant has 15 days to give you that declaration, and then he'd have to pay the 25%, not 100%, not 50, the 25%, and he doesn't have to pay that until February 1st. February 1st.
Okay, yeah, Carol, she's got her hands full here. Her tenants refused to complete and sign the form from the HCIDLA. Instead, they sent a letter clearly written by a tenant organization. Having tenants sign the HCID letter is not enforceable, is it? If so, how?
Okay, a tenant in, for example, Los Angeles, which is the territory that you're referring to, doesn't have to submit anything in writing. So while they have suggested forms by the HCLID, there is no requirement that they submit that. All they have to do is communicate to the landlord the three magic words: pandemic, COVID-19, or coronavirus. If they say those three magic words, your rent is deferred in Los Angeles for 1 year. So, but again, it runs afoul of what the state is saying. I think that landlords, and that's why I came and said that as of February 1st, if your tenants aren't paying your rents come February 1st for the rent due February 1st or beyond that in time, then you'll be able to serve a regular 3-day notice, no other declarations forms, and proceed forward with a normal eviction. As to the other rent, unless they didn't comply with the statute, you're basically going to be looking for your money somewhere down in the future.
Okay. So with this, Dennis, have you created all these dates within your Google Calendar so you can keep them straight?
Oh my God, I was up a couple of nights and also this morning trying to get these dates straight. But again, if anybody has any questions, they can always call our office at 1-800-77-EVICT. I think we fielded in the last 2 days over 680 phone calls in 2 days. So so we're on the phone and we're giving information.
Right, and all you know as well, for members, you can give us a call here as well. And it's been busy, so we're thankful for your patience. And here's another question. We have 3 guarantors who signed for the tenants in a 2-bedroom apartment. And one of them, they're due to COVID, they can't pay. There's 2 other parents that just haven't responded to that. And so, let me see. They said, I have sent the parents the statement from the HCID that states they're responsible for back rent and to please pay for their daughters. However, neither of those 2 parents responded. So what do you do?
Again, they don't have to respond. There's no obligation on their part. And a guarantor, while it seems like a pretty good idea that, if my tenant's not paying and you're a guarantor, you don't get any protection under the law. I mean, that's what it would seem like. This is the Tenant Relief Act. It's not the Guarantor Relief Act. So why can't I just go after the guarantor? By the way, they're the ones with the money anyway. Well, the reason why you can't is because the guarantor is guaranteeing the lease. And the lease says you got to pay your rent on time. But you see, those pesky people in Sacramento rewrote your contract for you. They say you don't have to pay your rent on time, that you have all these exceptions to paying your rent on time. So if the tenant doesn't have to pay the rent on time, then you can't ask the guarantor to say, hey, the tenant's breaching the lease, now you step in. The tenant's not breaching the lease. So a guarantor becomes worthless in terms of trying to go after them now. Eventually, you could go after them once that period is over and you're free to seek that civil debt. And that would be as of March 1st. You certainly could go after the guarantor, but there's certainly nothing you can do right now.
Okay. Let's see here.
By the way, no on 21, another intrusion into the lives of landlords where they're going to state that once your tenant vacates that you're not going to be able to raise the rent to the next tenant coming in excess of 15%. This is insanity. This is pure socialism, ladies and gentlemen. So if you can tell everybody that we have to vote no on Proposition 21, this is actually worse than this Tenant Relief Act. It's worse because this is for forever. At least the other one's going to be over as of February 1st. So please, everybody, please donate to the political fund of the Apartment Owners Association and get the word out. We must vote no on 21. It'll gut our industry.
Absolutely right. So put that bumper sticker on. Carol, there's the last question from her here. Can I send an invoice monthly indicating how much they owe? When the rent is split between people, though the split is not in the lease, should the invoice indicate rent for the entire apartment rent or only the history of the amount the person has been paying towards the total rent?
You can always send your tenant a notice, regardless of the jurisdiction, as to what rent is owed currently to keep tab on it. You're not making a demand to pay it because your jurisdiction might not allow you to make a demand, but you can certainly inform your tenant of that. Technically, when you serve a 3-day notice for that particular, a 15-day notice for the rent that's owed, if you served one in the month of September, the tenant would have to complete that declaration within 15 days. If you do another notice for October, again, the tenant is also going to have to send back that declaration. So for each time you serve the 15-day notice, which is going to be a lot of fun, just preparing notices and getting your declaration back from the tenant and serving another one. But again, the tenant is going to have to submit another declaration. But again, it's going to be pretty simple because you're giving him the form, and all he's got to do is check 2 boxes and sign his name and send it back. Yes, he's signing under the penalty of perjury, and even though he might have a new car in the garage, he's going to sign that he didn't have the ability to pay the rent because of the pandemic, and you're going to basically have to accept it.
Okay, here's a message from the chat. It's Peter, and he's asking, can the 60-day notices still be served, and can an eviction be processed based off that notice?
A 30 and a 60-day notice, let's say in a non-rent control jurisdiction, cannot be served unless one of those specific reasons that I talked about. You can serve them as of February 1st. A little known one that we've been doing, which I think walks the line between both local and the state law, is if you have a tenancy that's terminated. So let's pretend you had a tenant on a 1-year lease, and that tenant hasn't paid rent since March, and that lease is expiring on September 30th of this year. That's a lawsuit I'll bring right now as of October 1st. Because you see, this is not what they call a no-fault eviction. The lease said you were supposed to get out and you didn't. And I'm not seeking rent. I'd love to seek rent, but I can't. But I certainly can bring forth that lawsuit on October 1st on the basis that the tenant did not vacate timely. So that's one that we kind of have a little crack in. If that meets your situation, please contact us and we can go forward with that lawsuit, and we have, and we'll get a summons issued right now, and you'll finally get some relief, at least for that particular unit.
Okay, and let's see, the just cause, this is Peter again from the chat. Is just cause required on a 30 to 60 day? I kind of answered that. For even properties that would normally be exempt from just cause, such as single-family homes not in a rent control area.
Again, a single-family home based on this code section, which is not under any rent control, either statewide rent control, local rent control. It's not under any rent control. You have to have good cause now. Pursuant to statewide rent control, you would have to have good cause to evict. Again, the exceptions would be if you want a family member to move in, or you have to make a substantial renovation due to a problem, or you've sold the property and the new owner, call me silly, wants to move in. Then you'd finally be able to ask that tenant to vacate.
Here's a slightly different question from Peter. And so what about when the local laws are vague? And so like in this case, LA City has a moratorium with no given expiration date. It's open-ended. Do we need to abide by the LA moratorium or the AB 3088?
You'd have to abide by the local moratorium, which is up in the air. Maybe we should all call the mayor's office as soon as this seminar is over. Let's flood them with phone calls and say, hey, by the way, do you got a date for closing? Okay. I thought it was October 1st that this was going to be over based on the governor's order, but it's really open to interpretations. I know my associates are arguing with me as to when it's actually supposed to be over for Los Angeles and other municipalities, and quite frankly, I'm not sure. So let's give Eric Garcetti a call right now.
Okay, get those phone lines buzzing. Okay.
And also other jurisdictions as well.
Right. Are you aware of the basis of any basis for challenging the state's converting of a private business legally contracted debt for a service, which is housing, into a simple, possibly uncollectible debt? Like, is there a basis for that? Is there going to be any way that we're going to be able to?
Well, let me try to answer that one. I am contemplating bringing forth a federal lawsuit because this is the state on this lawsuit. We were somewhat successful against the Judicial Council and for making those emergency rules that stopped any eviction case in the entire state of California, excepting for safety and health, from proceeding forward. The Judicial Council didn't have that authority. They knew they didn't have that authority, and they finally gave up on August 31st, hopefully with the urging of my lawsuit that was at the California Supreme Court. The funny part was that the Chief Justice urged the California legislators to create this Relief Act, which I don't know, I thought judges were supposed to sit on the bench and adopt the laws as written, not to encourage people and become political, to urge the legislators, as our Chief Justice of the California Supreme Court did, urge the legislators to create this law that we're all suffering under. But I think this is clearly a violation of the United States Constitution under the contract clause, that they're rewriting our contracts for us. Man is supposed to be able to contract with his fellow man unless it's something against public policy. They're rewriting our contracts. So either my law firm, or I'm sure there's other law firms, are contemplating right now, and the dust hasn't settled with this this moronic Tenant Relief Act. It hasn't settled yet, but I do anticipate federal lawsuits being filed to enjoin this act. Where, as Dan said, where is it written that landlords are supposed to go without rent for a year or longer, and really that this is constituting free rent?
Here's a really good question from someone on YouTube, JD or Jay Dressler, it looks like. So it's not clear. Not sure it's clear that California is more restrictive than federal. In certain cases, you can proceed on October 5th under state law, but not until December 31st if the tenant submits the federal declaration. Not sure it's clear. Okay, that's just a repeat. Yeah. So, yeah.
That's a good question, and we're having trouble with that question because under the federal law, they have banned evictions through December 31st under the federal law. I'm somewhat shocked as to who was inspirational in creating that law, but it is what it is. However, with all due respect, our interpretation is that it has nothing to do with the state of California, because the law specifically states that the local states can create their own eviction protections. And so California certainly did. So I don't think we have to comply with any federal laws dealing with an eviction moratorium. That's my position right now, and it could change.
Okay, thanks. And here's one from Amy Lamb on YouTube. They have a tenant in a duplex in Ontario, both tenant occupied, and they claims to have COVID. He stopped paying rent because of job loss from illness. His wife and children moved out. When can I evict, if ever?
Well, again, you'd have to serve for any rent owed from March 1st through August 31st. You'd have to serve a 15-day notice with the declaration and the notice to the tenant. And if the tenant doesn't return that declaration within 15 days, you can proceed forward with an eviction. If it's rent beyond August 31st from September 1st, again, another different 3-day notice. This one has to advise them that if they do claim that the reason for their non-payment is COVID related, they would have to pay 25% of the rent, and they would have until January 31st to pay that.
Okay, great. And here's one from YouTube, Happiness for All. Tenant living, that's a housing provider right there. Tenant living in Los Angeles City RSO building claims that the LA ordinance that began on March 4th, 2020 still keeps him protected from eviction if he submitted a declaration that his income was dropped to zero due to job loss. Does he need to pay 25% of his rent to me in order to stay protected from eviction?
Well, you're under, that's the confusion, you're under the local rules. If the local rules say your rent is deferred, then he doesn't have to pay a penny until the local jurisdiction declares that the pandemic is declared over. So notwithstanding that the state is telling you that from March 1st through January 31st that you have to pay, not March 1st, I'm sorry, from September 1st through January 31st, that you have to pay 25%, that is held in abeyance based on the local jurisdiction.
Okay, great. And here's one from Smart Piggy on YouTube. What's the remedy for landlords who are taken advantage of by their tenants under AB 3088?
Well, there should be debtor's prison. Just throw them in jail. But again, your remedies are just what I have been talking about.
Right.
Now that we understand that tenants are taking advantage of the situation and not paying rent for months. I get phone calls, as I'm sure you guys are experiencing yourself who are listening to this and watching this, which the landlords that this tenant owes me $15,000, this tenant owes me $20,000. It just goes on and on and on. And I just don't understand how the landlords are going to have the wherewithal to proceed and keep their buildings with all these rental amounts that tenants are just playing games and not paying when they should, not even attempting to pay, even though they're going to work. You know, in our country, 90% of the people are working. We only have 10% unemployment. And of those 10%, how many were receiving assistance, be it unemployment insurance or giveaways from our federal government? How many were receiving assistance? Many people were getting paid more, but yet no one decided to pay their landlord that rent. So the truth of the matter is, I think there's a small percentage of tenants who are truly needy, but only a small percentage. And even for those small percentage of tenants that are truly needy, why is that landlord's responsibility? Mm-hmm. Why isn't that the federal government or the state government's responsibility to have a safety net for tenants who truly need help? Why is that put on the backs of landlords? The answer is it shouldn't be put on the backs of landlords. This is merely taking from one segment of society to another. But of course, we live in an entitled country right now where people just want to take and no one wants to give.
Right. Great. Okay, here we are. And let me see here. The question disappeared on me.
I'm going to do a couple more.
Yeah, Facebook. Here we have Sean Wild. If AB 3088 does not apply to commercial property, how do we get the phone number of our local municipality to find out the restriction for commercial property?
Well, I think if you listen to what I said just now, I think you have it all down. And if you don't, my friend, just give us a call at 1-800-77-EVICT. And with regard to commercial tenancies, based on your local jurisdiction, we probably can proceed forward with that eviction.
Okay.
Oh, and by the way, in many jurisdictions, while even for commercial that have restrictions for non-payment of rent, most of them don't have restrictions for terminating month-to-month tenancies. So what I mean on that is, if, for example, and I'll just take an example like Los Angeles, which says that rent is deferred until the pandemic is declared over, and then you have 3 months to pay it. But nothing prevents me from serving that tenant with a 30-day notice to vacate. So if you've got tenants that owe you rent and you don't see any light at the end of the tunnel, that their business is not going to come back and they're just hanging on, then in that I would urge landlords to serve notices to terminate.
Okay. Here's one. Prior to March 1st, my tenant brought in a roommate without prior written consent as required by our lease agreement. Roommates started causing problems, resulting in our tenant leaving the property and renting somewhere else. Roommate is living free in our property now. Can I evict the roommate immediately?
Absolutely, immediately.
Yeah.
I didn't catch whether the original tenant is already out. Is that what?
Yeah, he's already out.
Okay, so that's called an unauthorized subtenant at the end of the lease term. It requires a 3-day notice to quit, no other form required. And we've been filing a lot of those lawsuits. It's unbelievable to me that you have a tenant not paying rent, and then that tenant vacates, leaving someone behind. I mean, there's just no respect for landlords and their property. At least you had a problem. You didn't pay the rent for whatever reason. You left. You left somebody behind. Totally unfair for landlords. But yet we can file those evictions immediately.
Great. And here's one from YouTube. It's Chris, husband and wife tenants. He gave them notice on September 18th and paid that part of the rent. He says to get the rest of the rent from his wife. Her mother co-signed on the lease. Do I nail and mail all three or just her and her mom?
I would certainly mail it to the tenants. You can also send a courtesy copy to the guarantor. But you do have to send it to tenants. But you can serve the tenants unless you know where he moved to. You can serve the tenants by serving the property, either handing it to one tenant and mailing it to the tenant who has vacated at that same address. Or if no one answers the door, post one and mail one. I would send a courtesy copy to the guarantor. It might shake them up and get your money. I'm going to conclude this now. I want to thank everybody. And I want to, of course, thank the Apartment Owners Association for putting on this event. Quite frankly, I wouldn't be surprised if, based on this seminar, that you guys have more questions than the answers that you got. But we'll see what we can do about answering them. And I know the association is happy to answer your questions too. Dan?
If we give you those emails that have come in, will your office answer those?
We certainly will. So
all
we'll
the questions that were not answered will get answered then.
yes, they will.
By
We'll-
Dennis Block.
by Dennis Block. Hopefully you have an email address with them. So, but if not, you can send us an email. You can do that through my website at evict123.com. Thank you, everybody. I want to thank again the association for putting on this event. And guess what? We're going to have more of these.
Right.
So-
Thank you, Dennis, so much. Dennis,
Thank you.
really tremendous job. He knows so much. So we'll have these questions. We'll get them answered by Dennis, and we'll be able to put something out for you. I believe that's how we'll do it. And again, just want to remind you to subscribe to the YouTube channel, and if you leave a like for us, and we again remember September 17th, I believe that's the date. September 17th is going to be our next event with attorney Richard Beckman. So again, we'll do that live, and we look forward to seeing you then. Thank you.